Except for the Vatican City, the Philippines is the lone country in the world banning divorce. The only way to end a marriage, short of death, is to undergo a tedious and financially draining annulment process. But the pundits see new light, as the Philippine Supreme Court has taken a more liberal stance in its interpretation of psychological incapacity, in its recent pronouncement in the landmark case of Tan-Andal versus Andal. What does the Tan-Andal pronouncement mean in the future of annulment cases in the Philippines? And how does this pronouncement affect the institution of marriage? All this and more in today's episode of Prime Movers. This is Prime Movers, a legal podcast that covers the latest and relevant trends and insights on Philippine legal issues and topics, expertly discussed and diluted down by the experienced legal team at Gorriceta, Africa, Cauton, and Saavedra. Again, this is Prime Movers. In today's podcast, Ramon, André, Raffy Cedro, a key partner of the Gorriceta's litigation group, will be providing an in-depth discussion of the effects and repercussions of the Tan-Andal versus Andal case in the landscape of annulment in the Philippines.
Hi everyone, and welcome to the 5th episode of Prime Movers. This is André, partner at Gorriceta and a member of litigation, labor, data privacy, and real estate practice groups of the firm. Joining me today is Raffy Cedro. He's a partner and head of the Labor Relations and Employment Group at Gorriceta. He is also a key partner of the firm's litigation group with particular focus on complex litigation matters in arbitration, international investigations, and corporate governance issues. A finalist for Dispute Resolution Lawyer of the Year in ALB's 2020 Philippine Law Awards, Raffy also handles a variety of issues relating to family relations law, including nullity of marriage, the application and implementation of violence against women and their children law, succession, and estate management. Welcome to Prime Movers, Raffy.
Hi Ed, thank you for having me.
Okay, so Attorney Raffy, I understand that in the legal scene, we have heard about the recent decisions of the Supreme Court regarding marriages. To start, can you please give us a brief discussion about marriages in the Philippines? How is it characterized under our law? And is it really that tough to end marriages?
Well, see Ed, marriages in the Philippines are not only considered as simply a loving relationship between a man and a woman or simply a civil union. It's an inviolable social institution. When we say inviolable, it means that it's something that should never be broken. This is actually a characterization as seen in the Philippine Constitution itself. In other words, all of us are mandated as a sovereign people to protect marriage, as it is seen as a foundation of the family, and in turn, this foundation is a foundation of the nation, under which our state is interested in seeking its permanence.
You've mentioned permanence, Raffy. Does it mean that it is in the interest of the state for marriages to be permanent?
Yes, it is. Actually, not just for the state, also for society. You just have to think of it this way. The smallest unit of society, according to Aristotle, is a family. There can't be a society without families living in it. The nature or the character of a society will depend on how the individual families look within it. This, again, is supported by the Constitution.
So, is it correct to say then, given how the Constitution characterizes it, that marriage in the Philippines is quote-unquote forever?
Well, that is where the common misconception lies. It is true that a marriage has been described as inviolable, but legally, there are ways by which a marriage may be terminated in the Philippines, albeit for very limited and specific reasons. I'm talking about two ways. One, via petition for nullity of marriage, and two, via petition for annulment of marriage.
For the benefit of our listeners, Raffy, how do these two proceedings differ from one another?
Petition for nullity of marriage is resorted to when the marriage is void from the very beginning. In simple terms, this means that from the moment you say your vows and say, I do, the marriage has no effect whatsoever, because either one of you lacks essential or formal requisites of marriage, or your situation falls within those marriages considered void by law. Like, for example, let's say when you obtain a second marriage while your first marriage is still subsisting. In the eyes of the law, Your second marriage is without any effect because it is considered as a bigamous marriage by nature. But to clarify, a second marriage to be declared bigamous, a judicial order is still necessary. I don't want people thinking, since this person married more than once and it's already a bigamous marriage. It doesn't work that way. You still have to go to court to have it judicially declared as a bigamous marriage. Now, on the other hand, another way is via a petition for annulment of marriage. There is a valid marriage from the beginning, but because of the presence of some circumstances at the time of the marriage may be terminated. But this is only for a limited time, usually 5 years, depending on the ground invoked. And after the lapse of this limited time, you lose the opportunity to file a petition for annulment of marriage.
Okay, so let's focus on petition for nullity of marriage because that is what was filed in the Tan-Andal case, right? Can you briefly discuss to us what are the different grounds for nullity of marriage?
All right. Well, the Family Code provides for the grounds by which a marriage shall be declared void. Generally, these are 1. Marriages where any of the essential requisites of a valid marriage is absent. 2. Those considered bigamous. 3. Those considered incestuous. 4. Those which are void due to psychological incapacity. And 5. Marriages which are deemed void by reason of public policy.
You mentioned psychological incapacity. Can you discuss this further? What does psychological incapacity actually mean?
All right. Well, psychological incapacity is not expressly defined in the Family Code or in any specific law. As the Supreme Court noted in the case which you mentioned, Tan-Andal versus Andal, the Family Code Revision Committee deliberately refused to define the term psychological incapacity in order to, quote-unquote, allow some resiliency in applying the provision. The Family Code does not even provide examples which constitute psychological incapacity. However, the court, in numerous cases, has determined that the term should mean, and I quote, no less than a mental, not physical incapacity that causes a party to be truly incognitive of the basic marital covenants that concomitantly must be assumed and discharged by the parties to the marriage. It must also refer to the most serious of personality disorders clearly demonstrative of an utter insensitivity or an inability to give meaning and significance to the marriage. There's this particular interpretation is very, very wide in scope and has a very, very wide interpretation, really.
How can we prove this, Attorney Raffy?
Well, the court in the case of Republic versus CA and Molina laid down the guidelines for the application of Article 36, referring to psychological incapacity. I will be discussing only those which are very important, not necessarily everything that's stated in the Molina doctrine. Okay, so the court provided the following. 1. The burden of proof to establish the nullity of marriage belongs to the plaintiff. The root cause of the psychological incapacity must be medically or clinically identified and must be alleged in the complaint. 3. The incapacity must be proven to be existing at the time of the celebration of the marriage. 4th, it must be proven that such incapacity be medically or clinically permanent or incurable. 5, that the illness must be grave enough. The 6th is that the essential marital obligations must be those enumerated in the Family Code. And lastly, interpretations given by the National Appellate Matrimonial Tribunal of the Catholic Church in the Philippines, while not controlling, should be given great respect.
I'm curious, Raffy, how the Supreme Court has applied these guidelines in deciding annulment cases over the years. How were these guidelines used by the Supreme Court in deciding annulment cases? Did it result in a lot of cases favorable to the parties?
Well, you see, there are a lot of cases filed after the pronouncement of the Supreme Court in Molina, the case of Molina. In fact, the court described it as a deluge of cases. However, of all the cases filed from 1997 all the way down to 2008, only one case was found to have satisfied all the requirements in Molina, specifically the case of Antonio versus Reyes. In this particular case, this case involved a wife who was a pathological liar. Her tendency to lie in even the most mundane situations was ruled by the court as psychological incapacity, rendering her unable to comply with her essential marital obligations. All other cases seeking nullity of marriage on this ground that have reached the Supreme Court were all denied. This shows us that the Supreme Court really is very restrictive when it comes to the nullity of marriage. And then the Supreme Court recognized in 2009 in the case of Ngote versus Ute, where it stated and ruled that the Molina guidelines have unnecessarily imposed a perspective by which psychological incapacity should be viewed that is totally inconsistent with the way the concept was formulated. The court even stated that the Molina guidelines worked like a straitjacket, in which psychological incapacity cases were forced to fit those guidelines.
After the pronouncement of the court in the Ngute versus Ute case, are there any significant changes in how the court resolved annulment cases on the ground of psychological incapacity?
To be honest, nothing much really, except the seemingly continuous aversion of the Supreme Court in using the Molina guidelines, as can be seen from their pronouncements in the 2015 case of Calo versus Fernandez. And this is probably the reason why there are more cases decided by the Supreme Court which ruled in favor of nullifying a marriage.
And then came Tan-Andal versus Andal case. Can you give us a summary of the Tan-Andal case for the benefit of our listeners?
Alright, well, the Tan-Andal case is nothing out of the ordinary, It's just a case basically about Mario and Rosana who were married sometime around 1995. Prior to their marriage, Rosana already noticed, certain questionable behavior from Mario, including, going out with friends, having difficulty managing his finances, always irritable, always moody. It was only after their marriage that Rosana continued to notice emotional immaturity, irresponsibility, irritability, psychological imbalance on the part of Mario. So this actually led Rosana to filing a petition for nullity of marriage on the ground of psychological incapacity. The lower court, that's the RTC, granted the petition. But then, when Rosana went up to the Court of Appeals decided to reverse the ruling of the lower court and declared that the marriage was valid and subsisting. And the Court of Appeals stated that the psychiatric evaluation of Mario was unscientific and unreliable, and that it was based on guesswork and secondhand information. So, when the case went up again to the Supreme Court, this time it went up higher to the Supreme Court. The Supreme Court decided to rule against the Court of Appeals. According to the Supreme Court, psychological incapacity is not a medical but a legal concept. And, as such, it need not be proven that the respondent's spouse is suffering from a mental or personality disorder. Because of this pronouncement, the Supreme Court said that the testimony of a psychologist or psychiatrist is no longer mandatory. What is needed is a totality of evidence that would show a clear and convincing set of evidence to cause a declaration of nullity of marriage. So, in the case of Tan-Andal, the Supreme Court said that the consideration of the totality of evidence presented by Rosana would show that Mario is psychologically incapacitated, ultimately freeing her from a loveless marriage.
So, in what sense does this new Supreme Court decision change how we should approach nullity of cases on the ground of psychological incapacity?
Okay, this particular change or this particular decision of the Supreme Court has four main things that we should now consider and apply, for future cases. Okay, the first one, the pronouncement of psychological incapacity is not a medical but a legal concept. You see, in the past, counsels tended to establish psychological incapacity by proving that the respondent's spouse has a psychological disorder. That is why it's very common to see petitions labeling a spouse as suffering from schizophrenia, psychosis, or other personality disorder in the hopes of convincing the judge that the respondent's spouse is indeed psychologically incapable. It's also common to secure as witness a psychologist or a psychiatrist who would testify to these mental disorders. But with a pronouncement that psychological incapacity is neither a mental incapacity nor a personality disorder that must be proven through expert opinion, ordinary witnesses who have been present in the lives of the spouses before the latter contracted marriage may testify on behavior that they have consistently observed from the supposedly incapacitated spouse. From there, the judge will decide if these manifestations of behavior are indicative of a true and serious incapacity to assume the essential marital obligations. The second matter is the matter of incurability. It's the elimination of the element of incurability insofar as it is used in a medical sense. Because psychological incapacity is not and should not be treated as an illness in a medical sense, psychological incapacity is not something to be cured. In other words, the element of incurability should now be viewed in a legal sense, meaning the incapacity must be so enduring and persistent with respect to a specific partner. It contemplates a situation where the couple's respective personality structures are so incompatible and antagonistic that the only result of the union would be the inevitable and irreparable breakdown of the marriage. So that brings us to the third matter. The third change, is the reiteration that a psychological evaluation report is not required, since the existence of psychological incapacity need not be medically proven. While this is already the case even before the Tan-Andal case because of the non-categorical way this was presented in the past and several pronouncements which provide that psychological incapacity must be medically and clinically proven, many consider the presentment of the psychological evaluation report as required nonetheless. But now, the Supreme Court is more categorical, and we may see a shift in how parties would present their evidence in the future. And lastly, the new quantum of evidence required to prove psychological incapacity, clear and convincing evidence, though greater than preponderance of evidence, which is the default quantum of evidence in civil cases, this nonetheless provides parties with more leeway to prove the existence of psychological incapacity. All these things really gave us a whole new appreciation on how to prove psychological incapacity.
That's an amazing insight, Raffy. But just to further give our listeners a greater appreciation of how big this decision is, how do you see future nullity cases on the ground of psychological incapacity appreciated in our courts? And how exactly can the public, especially those who are in similar predicament as Rosana, benefit from this decision?
Well, you see, in this decision, an effort from our Supreme Court to address public clamor that has been going on for years with respect to the establishment of marriage in the Philippines. This is in their proactive stance, sort of like the Supreme Court saying to the public, yes, we hear you. And mind you, subsequent decisions cited the Tan-Andal case, showing that this decision is not going anywhere just yet. Now, with respect to the public, there would be less expense for them as they would not be compelled to engage the services of a psychiatrist or a psychologist to establish or to prove their ground. They would no longer be compelled to craft their petition in a way that would conform to the rigid and strict standards of the Molina guidelines, freeing them from the straitjacket which in the past restricted similar petitions.
You've mentioned earlier about the inviolable nature of marriage being mandated by our Constitution. So, how should we reconcile it with what you have just mentioned?
By liberalizing nullity of marriage on the ground of psychological incapacity, the Supreme Court is not weakening marriage as an institution. In my view, this decision strengthens the institution of marriage in the Philippines. One should not necessarily be blind to the realities that one may really be psychologically incapacitated to marry another. In fact, this new development of jurisprudence in the matter of psychological incapacity is more in keeping with the intention of the law.
Let us move on to another sensitive topic which is related to our discussion: abuses. I'm talking about a spectrum, not only physical violence, but also verbal, psychological, economic, and even sexual abuses. Are these grounds for nullity of marriage or annulment?
Unfortunately, they are not. Our current system of laws do not include abuses as grounds for annulment or even nullity of marriage. If you can show that abuses are the result of a psychological incapacity, they may be considered in nullifying a marriage. But even then, the ground is psychological incapacity and not per se based on the abuse.
Given that, Attorney Raffy, is there anything in our current system of laws that can somehow protect those persons experiencing abuse in the context of marriage?
Well, for one, there is legal separation, which certainly includes as grounds repeated physical violence and verbal abuse, among others. And then there's also what we have, the Republic Act number 9262, or the Anti-Violence Against Women and Children Act, or VAWC. This is a landmark legislation that defines and criminalizes acts of violence against women and their children perpetrated by women's intimate partners, like the husband or former husband, or any person who has or had a sexual or dating relationship, or with whom the woman has a common child.
You mentioned VAWC earlier. For our listeners, can you give us a very brief definition of it?
Well, when we say VAWC, or violence against women and their children, this refers to any act or a series of acts committed by a person against another, which results in any harm, suffering, battery, assault, coercion, harassment, or arbitrary deprivation of liberty.
Okay, so let us dissect the definition that you just gave. Before we go in depth with the acts or series of acts that are considered in violation of the law, can you please tell our listeners who are primarily protected by this law?
Well, the law protects a woman who is the offender's wife, former wife, live-in partner, former live-in partner, girlfriend, former girlfriend, dating partner, former dating partner, or against a woman with whom he has a common child, or against her child, whether legitimate or illegitimate. Essentially, when you say VAWC, it seeks to protect a woman and her child against the abuses of her intimate partner.
So, Attorney Raffy, who do we refer to as the offender here?
The offender here can be husband, former husband, or a man with whom the victim has or had a dating or sexual relationship.
So, it does not necessarily require that the victim and the offender are married?
Yes, that's correct. The law even contemplates past relationships. After the dissolution of marriage, or in case of unmarried couples, when you are already separated, once prohibited acts are committed against the victim, it's still covered by the law. It also includes unmarried couples who have a common child. Now, with regard to the child, the law protects their common child and even the child of the woman.
How can we say that two people are in a dating relationship?
Okay, well, two people are considered as being in a dating relationship when they live as husband and wife without the benefit of marriage. You see, there are couples who are under a live-in arrangement. It includes those romantically involved over time and on a continuing basis during the course of the relationship. These are people who are boyfriend and girlfriend, basically. But we must also take note that casual acquaintances or ordinary socialization between two individuals in a business or, let's say, a social context, now that's not considered as a dating relationship.
Regarding sexual relationship, can we consider the partners to be under such if there was only a single sexual act?
Well, yes, a single sexual encounter can bring them within the ambit of the law, yes.
So now that we know who the persons involved are, can you discuss the acts covered by the law?
Well, as I mentioned earlier, the law includes physical violence, sexual violence, psychological violence, and even economic violence.
Okay, so let us proceed with the first one. How can we say that an act constitutes physical violence?
Okay, well, there is physical violence when any bodily or physical harm occurs. So any kind of harm of this kind is included under physical violence.
So, Attorney Raffy, when is there psychological abuse?
When the act causes or is likely to cause mental or emotional suffering on the part of the victim, that's when psychological abuse comes in. The law even includes the word omission. It means that when the offender fails to do something which will cause such emotions to the victim, it is already considered psychological abuse. For example, let's say the husband is having an affair and the victim, the spouse, is aware of this. Naturally, this will cause distress and suffering to the wife. This act may constitute psychological abuse for the husband's failure to maintain fidelity.
Moving on, what about economic abuse?
Well, when the offender makes or attempts to make a woman financially dependent, that is what we refer to as economic abuse. I hope that our listeners can take note that even a mere attempt to do this already constitutes a violation of the law. Financial dependence is it's a very broad term. but the law makes mention of acts similar to it. This includes withdrawal of financial support or even preventing the victim from engaging any legitimate profession or occupation. This also can include deprivation or even threat of deprivation of financial resources or controlling the victim's money or property. Let's give a common scenario. Let's say a husband who is obligated by law to support his wife and children. If he suddenly decides to withdraw such support without any valid reason, it can already constitute economic abuse.
Attorney Raffy, you also mentioned that the law covers sexual abuse.
Yes, sexual violence happens when acts sexual in nature are committed. Again, this is a very broad definition. It may include rape, sexual harassment, acts of lasciviousness, and the likes. Even causing or attempting to cause the victim to engage in any sexual and prostitution of a woman and her child is considered sexual violence.
After familiarizing the listeners with those, let us now talk about how the victims can avail of the protection guaranteed by VAWC law.
Yes, the law gives the victims available remedies such as protection orders, the filing of criminal complaints, and even action for damages.
Attorney Raffy, for our listeners, what are protection orders?
Alright, a protection order is one issued by the appropriate authority for the purpose of preventing further acts of violence against a woman or her child and granting other necessary relief. Under the law, we have the Barangay Protection Order, we have temporary and permanent protection order. So let's focus on the TPO. This is what we call it. The temporary protection order and the PPO, the permanent protection order. Okay. These remedies can be availed of by a verified petition with the family court of the place where the woman currently lives. The TPO or PPO must be in writing. It has to be signed and verified under oath by the applicant in the family court, or if there is none, in any other court within the place of residence of the petitioner. It can be filed as an independent action or as an incidental relief in any civil or criminal case. The subject matter or issues thereof partake of violence as described in the Act.
What is the extent of TPO or PPO's enforceability?
Once it is issued, it's enforceable anywhere in the Philippines.
Once TPO or PPO is granted, what are the possible reliefs?
There are actually several granted by law, but it basically prohibits the offender from further committing the prohibited acts and will order him to stay away from the victim.
Regarding the other remedies, what criminal case can the woman file if there is any?
The woman, the victim, can file for a violation of RA 9262 before the regional trial court designated as a family court in the place where the offense was committed. This may also include a complaint for damages.
Until when can the case be filed?
Well, a violation under VAWC may be filed within 20 years from the occurrence or commission of the act against a woman or her child or children.
Wow, what an insightful discussion. To recap, we have discussed marriages in the Philippines, termination of marriages, the court's pronouncement regarding psychological incapacity, and even touching on the remedies provided to women and their children under the VAWC law. So for my final question, Attorney Raffy, I would like to ask you, what can you say about these developments and how may this affect the future of marriages in the Philippines?
I think these changes are a step towards a more progressive outlook towards marriages in the Philippines. We have to note that our family code took effect back in 1988 and embodied the principles and the current state of things back then, but it does not fully take into consideration changes brought about by time. We have to admit that our ideologies have differed through time, but with these changes being placed, such as the Tan-Andal case, the state seems to be taking active steps in reevaluating our laws to address the ever-changing state of affairs. As such, I believe we should expect more of these kinds of developments as the country tries to adapt to changes in conditions surrounding marriages. Regarding VAWC, the law has always been there since 2004. The challenge now is how the people will know of their rights under this law and how the courts would act upon them.
Thank you so much for your time, Raffy.
Yes, and thank you for having me today.
And that is it for our 5th episode of Prime Movers. We hope you enjoyed and learned from our discussion. In our next episode, We'll be talking about taxation in the Philippines. Make sure to catch it next time.